So what if the government could permanently strip you of your Second Amendment rights, not because you were caught committing any violent acts, but simply because you've engaged in activities like using marijuana or having marijuana, which the government does not like? That's exactly the question at the center of this critical Supreme Court case, U.S. versus Hamani. And the court's decision could reshape how far the government can go in deciding who the people are under the purposes of the Second Amendment. Now, before we jump into this video, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your front door every single month. And right now, TacPack is doing something special for my viewers. The next TacPack Plus box has a record amount of gear, including brands like Battle Arms, 9line, and others. And the total value of that Plus box is going to be over $330. And anyone who signs up for the first time, maybe for a TacPack Plus box, and you use my code ARMED, you're going to get that Plus box, you're going to get your subscription, plus a free gift of a tactical gear box worth at least $70. So if you're interested, check them out using my link down below. I will link to them. And don't forget to use my code ARMED to get that additional gift. So as I mentioned in the intro, in this video, we're going to be discussing a critical challenge that's currently in front of the Supreme Court. This case seeks to force the Supreme Court to determine who are the people mentioned in the text of the Second Amendment. This case revolves around 18 U.S.C. section 922 G3 and its restrictions on the unlawful users of controlled substances. Now, the question is whether the federal law here violates the Second Amendment. The primary battle in this case is not necessarily over the whole drug issue, but primarily who are the people afforded 2A protections. And the question is, does the Constitution protect only so-called law-abiding responsible citizens that the government defines them as, being, do they get to define that term of law-abiding citizens? Or does it apply to all people unless there's a clear proof by the government that that individual is a danger? This case, U.S. versus Hamani, actually pushed the Supreme Court to answer that question. Now, recently, the Fifth Circuit Court of Appeals threw the charge out against Mr. Hamani, saying that under its own precedent, the law cannot be applied to someone who wasn't actively intoxicated at the time that they were arrested or in contact with law enforcement, and at the time they were possessing that firearm. The DOJ is now begging for the Supreme Court to step in, arguing that this rule leaves a very dangerous loophole and precedent that the Supreme Court needs to correct. And the Supreme Court has now set this case for consideration at the Supreme Court's September 29th conference. So who is Mr. Ali Hamani, and what happened in this case? Well, from the outset, I will state that Mr. Hamani does not seem like a great person, and there's a lot of underlying factual issues in this case which are not good. This is not the perfect fact pattern by any means, and these are typically the type of factual cases that the federal government likes to push to the Supreme Court because the plaintiffs factually look horrible and they think they can get a win based on the factual issues in the case. Now, Mr. Hamani is a dual citizen of the US and Pakistan, and he's been on the FBI's, kind of radar for a very long time. In 2019, a search of his phone at a border crossing uncovered that there were communications suggesting that he was prepared to commit fraud on behalf of people tied to Iran and then other extremist groups as well. The following year, his family, him and his parents traveled to Iran, and they went to a celebration of essentially known extremists. Mr. Hamani kept close ties to Iran, including weekly contact with his brother that was at a university there in Iran that's known to and essentially flagged by the U.S. for being an extremist, university that has ties to extremists. But Mr. Hamani's problems really didn't stop there. The FBI also uncovered evidence that he was both using and selling illegal drugs, including prescription drugs, cocaine, and marijuana. Now, in response to this, the FBI got a warrant to search his home, and so they executed that warrant at his home. When agents searched his family home, they found a Glock 19, they found roughly 60 grams of marijuana and then several grams of cocaine as well. Now, Mr. Hamani admitted that he smoked marijuana nearly every other day, and he also admitted that all of those drugs were his. And because of this, he was charged with violating 18 U.S.C. section 922 G3, and he was indicted by a grand jury based on those charges. Now, in the district court, he filed motions to dismiss the charges, arguing that after Bruin and Rahimi, the Second Amendment does not allow a blanket ban like Section 922 G3. Now, the trial judge actually agreed with him and dismissed the indictment. And then this was appealed to the Fifth Circuit. And on appeal, the Fifth Circuit also affirmed the dismissal based on the Second Amendment. The Fifth Circuit based its ruling primarily based on prior precedents where the court had already held that it's unconstitutional to apply that section of federal law to someone who was simply a regular drug user, but potentially sober at the time of possessing that firearm. The government admitted that Mr. Hamani's case actually was indistinguishable from that prior precedent, so the appeals court upheld the dismissal and ruled against the federal government. That left the DOJ really with only one option. They decided to file for Supreme Court review. And in June of 2025, they filed the petition for review, and Mr. Hamani responded in July, and the DOJ filed their reply in August. And now this case is set to go to the justices this fall for a conference on September 29th. So what does the DOJ argue in their petition to the Supreme Court? Well, first they argue that history and tradition supports disarming people considered dangerous, including habitual drug users. They point to laws restricting guns from intoxicated individuals, the mentally ill, and other individuals as well. Second, they say that Section 922G3 is not a permanent ban. If someone stops using, drugs or prohibited items, they get their rights back. So they say that it's a reasonable restriction and it's only a temporary restriction. Third, they highlight a growing circuit split that the Fifth Circuit has struck down these types of laws as applied to individuals, but you have other circuit courts like the Seventh Circuit that have upheld these federal restrictions. And it's critical to note that they are saying that there is a clear circuit split right now between circuit courts like the Fifth Circuit and Seventh Circuit, and therefore the Supreme Court needs to step in and address this issue. So the circuit splits, along with the fact that the federal government here is the one asking for Supreme Court review, is very good for this case to potentially be granted Supreme Court review, because once you have a circuit split like this, kind of on the merits, and then you also have something where the federal government is asking for Supreme Court review, oftentimes the Supreme Court will grant review to these issues. The big issue I have, however, with this case, like I noted earlier, is the fact that it's a horrible plaintiff and not good facts for the Second Amendment. Now, why does this matter for all gun owners? Well, at least 30 states and territories have similar restrictions on drug users possessing firearms. And if the Fifth Circuit's approach actually stands, those laws could be pretty much on shaky ground and could become, into question and, potentially could also be overruled. Now, on the other hand, if the Supreme Court sides with the Trump DOJ, it could signal a broader willingness to uphold these type of restrictions on gun ownership for categories of people that the government deems too risky to be in possession of firearms, and could open a can of worms of larger enforcement of these types of laws. So the big question the Supreme Court will have to answer in this case if they decide to grant review is, does the Constitution protect only so-called law-abiding responsible citizens as defined by the federal government, or does it apply to all people unless there is clear proof of a danger? And this ruling will not just affect this one individual in Texas, it could also reset the boundaries of the Second Amendment for millions of Americans and other individuals who also have these types of active cases that they've been challenging post-Bruen, post-Rahimi. There have been multiple prohibited person cases like this that have made their way to the Supreme Court in the past. And now it seems like the federal government is pushing the Supreme Court to want to address this. You have a good potentially procedural posture of this case where you had the district court and the Fifth Circuit rule against the federal government, and now you have a circuit split along with the federal government petitioning the Supreme Court for review of this case. And again, they're going to consider this at their September 29th conference. So soon after that, we will have an idea of what the Supreme Court plans to do on this issue. So as we get more information, as it develops, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have the free legal guide available for you guys. If you want to get that, all you have to do is put in your email and we send you over a PDF. And then you can also check out my website there, armscholar.com, where we have other things like channel merch deals and all of that. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.